My name is Vivian Halstead from Travers Smith LLP, and this is a short talk on relational contracts. What are they and why does it matter? And perhaps most importantly of all, what is the connection between this topic and Mr. Whippy ice cream? To answer those questions, I'm here with Jonathan Rush, who, like me, is Knowledge Counsel in the Commercial IP and Technology Department at Travers Smith. Jonathan, can you explain briefly what a relational contract is?
There isn't a definitive test as yet, but the courts have indicated that relational contracts usually involve three things: a longer-term relationship, a substantial degree of commitment from both parties, and a high degree of communication and cooperation.
In practice, what sort of contracts would that apply to?
It's most likely to apply to joint ventures, complex outsourcings, where the customer and supplier need to cooperate quite closely to make it work, and in some cases, franchising or distribution arrangements. That's by no means an exhaustive list, but nor does it mean that all agreements of that type will be regarded as relational. It's very much a question of looking at the substance of what's been agreed, not what the parties have called it.
What about a contract for the sale and purchase of a business? After all, that's usually a pretty complex contract, often with a fair amount of money at stake.
I think that's unlikely to be relational, because the parties are usually looking for a clean break. Once the seller has sold the business, it doesn't expect to have much to do with the buyer anymore, so there's no longer-term relationship. There may be some transitional services arrangements, but they won't normally last much longer than 6 months to a year, and then after that, parties will go their separate ways. So it's essentially transactional in nature. Contrast that with a joint venture with an expected duration of perhaps 5 to 10 years, where both parents are contributing resources and expertise, and to make it work, they need to cooperate closely with one another on a day-to-day level over a significant period of time. Now that's much more likely to be a relational contract.
And what about a 20-year lease of commercial premises? Is that likely to be relational?
Well, that would obviously tick the box when it comes to the need for a longer-term relationship, but you also need to look at the nature of that relationship. In particular, how much regular interaction is there between the parties? With many leases, there are likely to be long periods where there's very little interaction between the tenant and the landlord beyond payment of rent. And given that, I think the courts will be quite reluctant to characterise the majority of leases as relational contracts in the same way as, say, certain types of joint venture.
Okay, now before we get on to why it matters whether a contract is relational or not, I think it's time we stopped keeping people in suspense and explain the significance of Mr. Whippy ice cream to all of this.
Well, it's all to do with a case called Amy and Birmingham City Council from 2018, where the Court of Appeal ruled that the agreement in dispute was a relational contract. It involved a massive PFI deal worth $2.7 billion over 25 years and 5,190 pages long, under which Amy was responsible for managing and maintaining the council's entire road network. This deal gave rise to numerous complaints about Amy's failure to repair roads adequately. It's also given rise to some intense competition between local journalists in Birmingham to find the best way of demonstrating just how bad the roads were. So one reporter filmed himself being driven over a series of potholes, trying to hold a very full glass of water, but I think the award for best Amy-related pothole video has to go to the reporter who was filmed while attempting to eat a Mr. Whippy ice cream, most of which ended up all over his face.
Just in case anyone is tempted to try this themselves, I think we should make it clear that the reporters were in the passenger seat while they did this. They weren't actually driving themselves. Meanwhile, I gather that the contractual dispute has generated a fair amount of press coverage in its own right, especially when the council imposed penalties on Amy of almost £50 million for failing to replace a mere 2 sets of damaged bollards. So what actually went wrong with the Amy deal?
Well, the contract appeared to be working well until 2014, when, according to the Court of Appeal, Amy thought up an ingenious new interpretation of the contract, which would have the effect of reducing their workload or increasing their profit if they issued change notices. That interpretation essentially involved a very strict reading of certain provisions of the contract, If upheld, it would have meant that Amy was only under an obligation to maintain roads listed in a dataset which was known to be out of date, and it didn't include significant parts of the council's road network. Amy argued that it was not the court's function to rescue parties from bad or even disastrous bargains which they make, and at first instance, the trial judge agreed.
But I gather the Court of Appeal took a different view. Why was that?
The Court of Appeal described the outcome at first instance as most bizarre, given that the whole purpose of the contract was to maintain the entirety of the council's road network. It took the view that this was a relational contract, which would only work if both parties were prepared to cooperate with one another and, as they put it, adopt a reasonable approach in accordance with what is obviously the long-term purpose of the contract. Because of the long-term nature of the contract, it was inevitable that the contractual obligations of Amy would change over time. This supported the existence of a general obligation on Amy to update the road network data. The Court of Appeal also said that, with a contract of this length, there were bound to be inconsistencies and instances of bad drafting. It wasn't helpful to almost exclusively on a small number of provisions in isolation from the purpose of the contract as a whole, which was, after all, to maintain the whole of Birmingham's road network, not just some of it.
But I thought that more recently, the trend in contractual interpretation had been towards a more literal approach, especially in disputes between well-resourced, sophisticated parties. In this case, it sounds as if the Court of Appeal placed more emphasis on the interpreting of the words in the light of the overall purpose of the contract.
You're right that recent Supreme Court rulings have suggested a shift towards focusing on the natural meaning of the words used, even if that sometimes produces some rather uncommercial outcomes. And if the contract had not been relational, then it's entirely possible that Amy's strict interpretation would have prevailed. For example, if it had been a sale and purchase agreement. But what the Court of Appeal seems to be saying in this case is that a more purposive approach can be justified where you have a relational contract, especially a very long, complex one like this. In particular, a point may be reached where focusing on the natural meaning of the words used starts to have diminishing returns, because the contract is so long that each side can easily find individual provisions which support their view. The only way to decide which interpretation is to be preferred is to take a step back and look at the overall purpose of the contract.
Is there likely to be an appeal to the Supreme Court?
That's unlikely, because the council announced in July that they had reached a settlement with Amy. Now that's probably good news for long-suffering drivers in Birmingham, as it enables the council to move on, but it does mean that as lawyers we still don't know what the Supreme Court thinks about relational contracts.
Okay, so that's one example of how finding that a contract is relational can make a difference to the outcome. Our next example is a case from March 2019 called Bates versus Post Office. Can you explain what this one was about?
This litigation arose out of a very long-running saga involving the post office and some of its sub-postmasters who run post office branches. Based on discrepancies in their accounts, these sub-postmasters were accused of theft, fraud or false accounting, and their contracts were terminated. Some of them have even been convicted and sent to prison. The sub-postmasters argue that these discrepancies arose because of errors in the post office's own computer system known as Horizon. The courts haven't yet reached a view on whether that's correct, but there's a fair amount of evidence in the public domain that the Horizon system was far from perfect and was indeed prone to errors.
I gather the litigation has been very hard fought, and the post office has been accused of some fairly heavy-handed tactics in its dealings with the sub-postmasters.
Yes, when interviewing sub-postmasters who were under investigation, the post office told them that if they disclosed anything that was said at the interview, they would be in breach of the Official Secrets Act. The judge was less than impressed, describing this tactic as unusual and oppressive. The post office has since accused him of bias, but that allegation has been rejected by the Court of Appeal.
So what does this case tell us about relational contracts?
Well, among other things, the judge found that the post office's agreements with sub-postmasters were relational contracts. This meant that a wide-ranging duty of good faith was implied, or as the judge put it, the post office is not entitled to act in a way that would be considered unacceptable by reasonable and honest people.
Why is that so problematic for the post office?
It affects them in a number of ways, but to take just one example, the post office has been exercising its discretion to suspend or terminate sub-postmasters' contracts unless they could prove that the discrepancy wasn't their fault. So in effect, it's been presuming guilt unless shown otherwise. This is against a background where, as I mentioned earlier, there is evidence that the Horizon computer system may have been at fault. Although we haven't had a judgment yet on breach, it's by no means impossible that the Post Office's conduct will be found to have breached this duty to act in good faith.
Does this ruling mean that good faith will be implied into all relational contracts?
Not necessarily. For example, there's no suggestion in the Amy case that such was present, and the judge in Bates made it clear that where a contract dealt with good faith expressly, for example by requiring it to be observed in relation to some provisions but not others, then it would not normally be appropriate for the courts to imply a general duty to act in good faith in relation to the whole contract. That's because the parties had clearly applied their minds to the matter and decided against that approach. The rationale for implying it here was that the judge took the view that the contract necessitated a high degree of cooperation and trust to make it work.
So what's the next stage in the post office litigation?
A judgment is expected later this year on whether the Post Office actually breached the terms of its contracts with sub-postmasters, so that will be worth keeping an eye out for.
OK, so if I could just try to sum up, there seem to be two main points here. The first is that a finding that a contract is relational can have a significant impact on how strictly it's interpreted, as we saw in the Amy case. And the second is that it may also result in a wide-ranging duty of good faith being implied, as we saw in the Post Office case. Is there anything you would add to that?
Just to expand on both those points, it can affect how you exercise your rights under the contract, so you may need to ensure that you're acting consistently with the purpose of the contract and in a commercially acceptable way, and you may also need to avoid exploiting defects in the drafting or an imbalance in bargaining power. But it's important to keep these cases in perspective. The Post Office case in particular is quite unusual, and the vast majority of contracts are not relational but transactional. So we're really only talking about a small subset of commercial contracts generally. It's also important to bear in mind that the concept has yet to be tested in the Supreme Court, although in my view the concept has been sufficiently recognised at Court of Appeal level that it would be unwise to dismiss it as just a passing fad.
Thanks for answering those questions, Jonathan, and thank you for listening. Please note that this talk is not a substitute for detailed legal advice. If you'd like more information or you have any feedback on this talk, you can contact us at commercial@traverssmith.com.